Good morning, everyone. Welcome to Assembly Judiciary. You can see everyone's a little extra rowdy this morning because they're still recovering from the basketball game last night. And with that, Secretary, please take the roll.
Assemblywoman Bilbray Axelrod. Assemblywoman Cohen.
Here.
Assemblywoman Considine.
Present.
Assemblywoman Gallant.
Here.
Assemblyman Gray.
Fine.
Assemblywoman Hanson. Assemblywoman Hardy.
Here.
Assemblywoman LaRue Hatch.
Here.
Assemblywoman Marzola.
Here.
Assemblywoman Mosca.
Here.
Assemblywoman Newby. Assemblyman Orentlicker.
Here.
Assemblywoman Summers Armstrong.
Present.
Assemblyman Urick. Chair Miller.
Here. And with that, just a few reminders before we get started. Again, asking everyone to turn down their volume on any of their electrical devices. We will have a public comment section at the end of today's meeting. Just a friendly reminder, too, that we appreciate that when you're able to turn in any of your meeting materials when you have a scheduled hearing the day before by 12 noon. And with that, I think that's all. We all know how this all works, so I'm going to open up the first hearing that we have on our agenda today, which is SB 14. SB 14 makes various changes to gaming, and it will be presented by Kirk Hendrick, who is there in Las Vegas presenting for us. He is the chair and executive director of the Gaming Control Board. And with that, Mr. Hendrick, your hearing is open, so please proceed when you're ready.
Good morning, and thank you, Chairwoman Miller, Vice Chair Marzola, and members of the Assembly Committee on Judiciary. As stated, for the record, I am Kirk Hendrick, Chair of the Nevada Gaming Control Board. First of all, I want to thank Chairwoman Miller for allowing me to appear via video conferencing from Las Vegas this morning. Very much appreciated because I will be chairing the Gaming Control Board's regular monthly Gaming Control Board meeting at 9 a.m. this morning here in Las Vegas, so thank you for that. I also would like to introduce with me here in the room today Christy Torgerson, who's the Chief of the Enforcement Division of the Board, Jim Barbie, Chief of the Technology Division, and Nathan Riggle, the Deputy Chief of the Administration Division.
Mr.
Additionally,
Hendrick?
I want to recognize Mr. Yes.
I'm sorry, before we go further, are they going to be co-presenting with you, or are they just available for questions?
Just available for questions.
Thank you.
Thank
Please.
you. Additionally, I want to recognize Mr. Michael Morton, Special Assistant Attorney General, who is there in the room with you in Carson City today, and acknowledge all of his help on this bill. As stated, I am here today to present SB 14 in its first reprint. Senate Bill 14 seeks to make various minor changes to Chapter 463 of the Nevada Revised Statutes and to make it more efficient to handle the board's licensing process that is essential for the strict regulation and success of the gaming industry. With the chair's permission, I will first go through the bill by topic area and then present one proposed amendment to the bill. The first topic the board would like to present in SB 14 is Section 1. Under the current statutory and regulatory framework, if a licensee were to pass away or become disabled, the estate of the deceased individual has 30 days to notify the board of such death or disability and to file an application with the board for temporary licensure to operate the gaming establishment owned and operated by the deceased or disabled licensee. That application then goes through the board's standard licensing investigatory process, just like any other application that would come before the board. As you can imagine, when a family loses a loved one, filing gaming paperwork is certainly not the first thing that comes to their mind. So during public board and commission meetings, members are often expressing their sympathy to families of their loved one, while at the same time having to explain the possibility of disciplinary action for late filings of temporary license applications. Therefore, Section 1 of SB 14 would authorize the chair of the board to administratively approve continuation of the gaming establishment by select individuals while the application is being processed by the board. This would allow the licensee's estate to more efficiently administer the disposition and closing of the estate while still complying with all applicable gaming laws and not having an unlicensed individual conducting gaming operations in the state. Sections 3, 4, and 9 make conforming changes to NRS based on the proposal in Section 1. Section 1.5 of the bill addresses necessary changes to the definition of gaming employee. As the committee's probably well aware, dating back to when the definition of gaming employee was added to the Nevada Revised Statutes back in 1981, the definition has been amended 18 times. The definition has been amended in nearly every session since its original enactment because of the speed at which the gaming industry evolves. As the industry grows and changes, there are new types of employees that the board and commission believe are necessary to be registered, or in some cases actually not registered with the board. Between legislative sessions, however, the board's enforcement division often finds itself trying to fit new types of gaming employees into existing statutory framework, which sometimes leads to confusion for both the industry and for board staff. This proposed change to the definition of gaming employee in Section 1.5 seeks to do two things. One, update outdated terms that are no longer used in the gaming industry, and two, provide enough of a framework within the statutory definition so the commission, if deemed necessary, may adopt regulations relating to who is and who isn't a gaming employee if the need arises during a legislative interim. Moving on to Section 2. Currently, if the board determines that a debt is owed to the state by a licensee or former licensee, and if it's impossible or impractical to collect, the board must make a request to the State Board of Examiners to designate such a debt as a bad debt. Upon a vote by the Board of Examiners to designate such an amount as a bad debt, the state controller is directed to remove the bad debt from the books of the state, although it remains a legal obligation owed to Nevada. Section 2 of SB 14 would streamline the process of designating bad debt by reorganizing the steps of the process. The proposal would allow the board to determine if a delinquent debt is impossible and impractical to collect, and would authorize the chair of the board to notify the state controller of such a determination and remove the debt from the books of the board. The state controller would then seek to remove the debt from the books of the state before the Board of Examiners. Section 11 makes a conforming change to effectuate this proposal. The board is requesting this change to close out its books more efficiently each fiscal year. It's important to note that the board rarely utilizes bad debt removal process. The last time the Game Control Board went before the board examiners was in 2021, and that was for the designation of approximately $1,655 as a bad debt. For fiscal year 2022, the board collected nearly $1.2 billion in taxes and fees and is only attempting to collect $1,035. This amounts to a collection rate of over 99.99%. Because a gaming licensee is a privileged license, the board has broad authority and tools to collect gaming taxes and fees. Therefore, by the time the board is seeking a bad debt determination from the board of directors, it means there's practically nothing else the state can do to collect that debt. Consequently, Section 2 efficiently administers the board's internal accounting with the state and streamlines the process. Now turning to Sections 5 and 6. Here the board seeks to make consistent language in two statutes that both address the venue for judicial review of gaming matters. As written in the first reprint of SB 14, these proposals are technical revisions and do not make any substantive changes to the venue statutes. Rather, the revision will simply make both provisions read the same way. Section 7. The next topic is Section 7 of the bill. In NRS 463.373, the statute imposes a quarterly slot tax on restricted licensees on the number of slot machines being operated. The new language in subsection 5 of Section 7 requires those who receive a share of revenue from the operation of slot machines to pay that person's proportionate share of the quarterly slot tax. This proposal would make consistent various statutes regarding quarterly fees and annual slot taxes when proportional shares of license fees are involved. The newly proposed language already exists in NRS 463.375, which imposes non-restricted quarterly fees, and NRS 463.385, which imposes the annual slot tax. Therefore, this proposal would make consistent the imposition and collection of all slot taxes imposed by the state. The proposal would not change the amount of quarterly slot tax collected by the state, but would ensure that each licensee is paying its accurate share of the tax. Moving on now to Section 8 of SB 14. Currently, NRS 463.386 authorizes the chairs of the Nevada Gaming Commission and the Nevada Game Control Board to administratively deem certain licenses upon transfer as a continuing operation, which allows the transferee to collect prepaid taxes and fees from the transferor. For consistency, the board is proposing the addition of the following license types to administratively authorize the following taxes and fees. And pardon me while I go through these for the record. The disseminator's license in our NRS 463.450 is 4.25% monthly tax. The manufacturer and distributor licenses in NRS 463.660 is a $500 annual fee. The interactive gaming service provider license in NRS 463.667 is a $1,000 annual fee. The license of a manufacturer of an interactive gaming system in NRS 463.760 is $125,000 initial fee, $25,000 annual fee thereafter. The interactive gaming license in NRS 463.765 is a $500,000 initial 2-year fee with a $250,000 annual fee thereafter. And the license to operate a parimutuel system in NRS 464.015 is a $500 annual fee. Because these fees are not refundable, the state may occasionally experience a slight loss in revenue because of the transfer of taxes, but that would only happen if existing operations are purchased by another individual or entity, and then only if the chairs of the board and commission deem there to be a continuing operation. This change is important to note would treat all licenses and relevant licenses for a licensee in the same manner and would save the board time and resources. Currently, multiple licenses held by a licensee could be treated differently. These companies are reviewed and audited by either the board's audit or tax and license division on a regular basis. Consequently, the board and commission are confident in that only deemed transfer licenses of continuing operations would happen when appropriate. Section 9.3. Section 9.3 of the bill seeks to modernize the statutes of governing evolving forms of gaming. As certain gaming licensees and service providers used by gaming licensees utilize cloud services, the board and commission needs to have the ability and the agility to properly regulate such services. Section 9.3 gives the board and commission the regulatory authority to do just that, while sections 2.5, 9.5, and 9.7 make conforming changes to effectuate that purpose. Essentially what that does is allows the ever-evolving change of cloud services to be utilized by licensees when approved by the board. Section 10.5. Lastly, Section 10.5 seeks to address an issue unique to the Nevada Gaming Commission and state employment. Currently, unless certain limited exceptions apply, a former state employee who's collecting benefits from the Public Employees Retirement System cannot be concurrently employed by the state. While understanding justification for such a prohibition, it has posed a unique problem based on the gaming regulatory structure here in Nevada. As all of you know, gaming in Nevada is regulated by a 2-tier system, the Gaming Control Board and the Nevada Gaming Commission. While the 3 members of the board are full-time employees, the members of the commission are part-time employees entitled to a statutory salary pursuant to NRS 463.026. Pursuant to the prohibition I mentioned, a former state employee who may be appointed to the commission would be unable to keep collecting his or her PERS benefits while also earning the statutory salary for a commissioner. In finding the most qualified people to serve on the Nevada Gaming Commission, one place a governor may look is to a former government employee, those who have vast amounts of experience in gaming, accounting, or law enforcement, for example. However, due to the salary prohibition against earning while also being part of PERS, it is not feasible for a retired state or local government employee to pause PERS benefits to earn the statutory allowed $40,000 per year. Section 10.5 seeks to eliminate this problem for the very narrow purpose of appointment to the Nevada Gaming Commission, and the board thanks the staff at PERS for their help in finding this solution to the issue. Finally, I'd like to bring up the one small amendment that the board has in front of you today. The board has submitted a minor amendment to SB 14, which seeks to revert Section 3 of the bill back to the way it was drafted when the bill was introduced. After continuing conversations with stakeholders, it was determined that the matter needs further vetting and will be best considered through the regulatory process, so that section was put back to as originally proposed. Thank you, Chairwoman Miller. This completes the board presentation of SB 14, and I'm happy to answer any questions that members of the committee may have.
Thank you so much for your presentation. I would like to start with the first question from Assemblywoman Cohen.
Thank you, Chair. Director, I do have a question. It is in section 1 about the temporary engage. So there's no language there about any kind of limits. Was there any consideration put into putting, or was there any consideration made to putting some sort of guidelines about how long this can go on, under what circumstances this can happen? Or it does seem like it's really very broadly drafted.
Kirk Hendrick for the record. Thank you, Assemblywoman Cohen. Yes, there is language that the chair may condition or limit any administrative approval pursuant to the section. That's in subsection 2 of section 1. And the idea is this is a temporary procedure, so the applications still need to be filed, and usually the estate is moving very quickly. The probate attorneys are doing everything they can, so the process generally doesn't take very long, but it's that interim piece where someone is finding out that they are not licensed, and we have an unlicensed entity being run in Nevada without anybody having proper authority to do so.
And I'm sorry, I didn't ask that very clearly. I was more concerned about the fact that the chair is given the sole and absolute discretion, and there's no guidelines on the chair's ability to approve the spouse or the personal representative. Was there any consideration made to putting some guidelines on the chair so that the chair has to work within the time of the probate, or 6 months, something like that, something to kind of just put some guidelines into the statute?
Kirk Hendrick again for the record. That, as we were drafting this, did not come up. The language that you see about sole and absolute discretion of the chair, that's used, I think, 6 or 7 times in NRS 463 and 462, and it's used dozens of times throughout the Nevada Gaming Commission regulations. It doesn't limit it as you're speaking about, but again, the application process is moving forward, and the matter would end up on a public agenda in front of the board and commission in due time.
Are you asking for a follow-up?
Yes.
Proceed.
Thank you, Chair. And then, thank you for that. And then, so you mentioned this happening before, and I think of our gaming industry as being very corporate now. So can you tell me approximately how many times this has happened where you have had families before you and they do have issues? And are we talking about, I'm assuming these are just people with restricted licenses, or are these some people with unrestricted licenses? Can you just kind of give us the example of what's going on now in more detail?
Kirk Hendrick for the record. Yes, I'd be pleased to do that. So I've been chair of the board for 3 months, and I've already seen 3 of these examples. And to your point, no, this is not the large hotel casinos that you would be seeing with non-restricted licenses. Generally, these are families who have owned a restricted location, such as a bar, possibly a convenience store, a laundromat, the type of people who don't have a compliance committee, the type of people who sometimes have not done their estate planning properly. And so, as I mentioned during my presentation, this will come up and the family won't even know about it. And so they're just not thinking about it. But to answer your question specifically, yeah, it's happening almost monthly at this point, but it's generally the small locations.
Okay, thank you. Thank you, Chair.
Thank you, and I'd like to follow up on the Assemblywoman's question. Can you just, as you're saying temporary, and we understand the reasonings behind providing for temporary, but I guess I'm trying to figure out what temporary is. And when we talk about interim and temporary, in just real life application, I've seen temporary, or I've seen someone put in as an interim leader. From that interim can sometimes last a month, and then sometimes it's 3 years later. This is still we're still in the interim, and it's still temporary. So could you just specify what would be considered temporary and why there aren't definitive parameters around what temporary is?
Kirk Hendrick for the record. Yes, thank you, Chair Miller. The temporariness of this is just while the estate is having filed their application and going through the process of somebody either being licensed. A lot of times, as I mentioned, these are small locations and the estate is generally trying to sell the property. So the application may be to sell it through the estate, or it may be, as mentioned in Section 1, subsection 1 of Section 1, it's usually a spouse, next of kin, personal representative, guardian. And so the temporary is so that somebody can be administratively approved immediately rather than waiting on a normal application process to happen, which could take several months, assuming even if they were to properly file the application within 30 days required by the law.
So are you suggesting that the temporary is usually only about 30 days? Because again, we know these proceedings can go, this process can go on quite a while as well. And if that's the case, why isn't there some type of parameter in this suggesting what temporary would be?
Kirk Hendrick for the record. No, it's not the temporary being 30 days. It's the fact that they have to file an application in 30 days, which is where they usually run afoul of the statutes. The temporary would be that the chair could approve a temporary while the application process is going on. That could still take several months. If the committee needs more specifics on the average amount of time of that, I would need to probably have the chief of the investigations division work up a memo to explain to you how long these normally take. But this is so that there's not an unlicensed location while the process is happening, and that's generally what happens here. A lot of times people don't file the application. That's a violation of the law and the regulations, but even when they do file an application, you're still talking about a temporary time period while they're not licensed. This would solve that by allowing chair to temporarily license somebody while the application process proceeds.
And maybe I should ask the question this way. What is the obligation or requirement? How much time does the chair have in order to do that? Is this something that happens immediately upon notification? We call our next meeting, we jump into action? Can you explain that process?
Yes, thank you. Kirk Hendrick for the record. It would be administratively handled. So assuming you have a licensee that files a notice that a licensee has either died or become disabled, this would become an administrative matter handled through the investigation division and the application process. Chair would approve it probably within a matter of days because, again, it's the list of people that you would expect it to be. Spouse, next of kin, executor, those type of people. That would happen very fast.
Thank you for that. Our next question will be from Assemblywoman Newby.
Thank you, Madam Chairwoman, and thank you for presenting this bill. I have a question on Section 9.3, subsection 6, on the regulations to be adopted, and in extension, I guess, subsection 5. I'm just curious, it seems like the current law already allows for regulations to be adopted in that area, so I'm wondering how interactive gaming and the cloud services are regulated right now. Are there already regulations, or are you seeking the opportunity to be able to develop those?
Thank you, Assemblywoman Newby. Kirk Hendrick for the record. With the chair's permission, I'd like to ask Jim Barbie, the chief of the technology division, to come forward and answer that question.
Absolutely, thank you. And Mr. Barbie, when you respond, will you please also spell your name for the record, please?
Yes, Madam Chair. My name is Jim Barbie, B-A-R-B-E-E. I'm with the Technology Division of the Nevada Gaming Control Board. Assemblywoman, currently there is enabling language in the statute that the Commission adopt regulations regarding service providers. However, that language is very specific in that it requires the language or the regulations adopted by the Commission to state that the Board and Commission have absolute authority over the premises on which certain service providers operate. This change that's currently proposed would allow the commission some discretion on where to apply that absolute authority.
Thank you.
Thank you. Our next question is from Assemblyman Urick.
Thank you, Chair, and thanks for the presentation this morning. My question goes to kind of at the end, you had talked about a decision to present this again today with this amendment that is dealing with Section 3, Subsection 4. I was looking it up here and trying to make sense of it. Can you just talk a little bit more about the timing and the purpose behind the decision to go back?
Kirk Hendrick for the record. Thank you, Assemblyman. Yes, so when this was proposed, the bill would have been drafted last summer by prior administration, prior chair. And the thought behind that, from my understanding, is that the board wanted some greater definition and control over who was running a sports pool. And the idea is, as the sports industry is evolving, as you see across the country, there's becoming a lot of co-branding and co-affiliate relationships. And what the board wants to be sure is the actual licensee is the one who is running the book and making the most responsible decisions when it comes to finances, when it comes to advertising, when it comes to who's the responsible employees that has the gaming employees. We believe the industry is doing that, but there was some question about whether or not it should be better defined in statute. That came up, some conversations came up with the industry over the last several weeks, and quite frankly, the amendment started to get so big that I didn't want to bring it in front of the committee and bog down this bill, and I just thought it made more sense to take it back to regulation, give the industry time to vet it along with board staff, and see if we can make sense through it with regulation.
Thank you, Chair.
Thank you. And with that, I don't see any additional questions. So we will go ahead and open it up for testimony in support of Senate Bill 14. If there's anyone here in Carson City that would like to approach and testify in support? Not seeing anyone. Is there anyone there in Las Vegas that would like to testify in support? Please remember to state your name and spell it so we have it correct for the record.
Thank you. Chair, my name is Virginia Valentine, Valentine, and I am with the Nevada Resort Association. I'm here to speak in support of SB 14 with the amendment to Section 3 to revert to original language for the board, and also to thank Chair Hendrick and the chiefs at the Gaming Control Board for working with us on the amendment for cloud computing. We see this as a modernization effort. Now, when you are looking at data on a server, there are, with cloud computing and the whole volume of the activity that goes on now with service providers, you have a combination of both encrypted and unencrypted data. And what we want to do is continue to work with the control board to get a regulation that will allow us to work with them to provide the data they need when they're doing an investigation. So thank you again. We urge your support of SB 14.
Thank you so much. Is there anyone else there in Las Vegas that would like to testify in support? I don't believe so. Broadcasting, will you open the lines for those who would like to testify in support?
There are no callers at this time.
Thank you for that. Then I will open it up for opposition testimony, beginning here in Carson City. Not seeing anyone. Is there anyone there in Las Vegas that would like to testify in opposition? Also not seeing anyone. Broadcasting, please open the lines.
There are no callers at this time.
Thank you. Then I will open it up for testimony in neutral, beginning here in Carson City.
Good morning, Madam Chair and members of the committee. For the record, my name is Kabrina Fazer, Kabrina Feser. I'm the Operations Officer for the Public Employees Retirement System of Nevada. At their February 16, 2023 meeting, the Retirement Board voted to be neutral on Section 10.5 of Senate Bill 14. If there was an amendment to only provide a very limited reemployment exemption to the Gaming Commission members. The current language satisfies this requirement. As Chair Hendricks spoke of, there is a salary limitation for reemployed retirees. It's currently at $27,495.50. And so, as Kirk Hendrick stated, the commissioners, which is a small group, a 5-member commission, their part-time salary is $40,000 per year. So it is in excess of that earnings limitation, which kind of brings us to this amendment. So that's all I have. Thank you.
May I ask you a question?
Of course.
Thank you. It was also said during testimony, alluding to the fact of how cumbersome it would be for the PERS system to stop and start and all that on someone's benefits. And I'm wondering, because I know just with my own mother's experience, who it took her 3 times to officially retire. She kept, I'm going, and then would do it sort of for like a year and then go back to work kind of thing, right? I'm sure that's pretty normal now for many people. And during that time, she would start her Social Security and then, no, I'm going back to work. And so she literally just, and I had no idea that you could literally just stop and start your Social Security like that. And I'm thinking of other examples of people that stopped and started or paid back Social Security, so I'm just wondering where Social Security is, a massive federal program in this nation, massive, bureaucratic and often cumbersome for the recipient. I'm just wondering if people are able to do that federally, is it really that challenging then for the state of Nevada, especially if you're speaking on just a handful of people?
For the record, Cabrina Fazer. Thank you for the question, Chair. As far as Social Security goes, me and my staff, we always say we are not Social Security experts by no means.
No, I'm not asking. I'm just saying for you to stop and start.
On the PERS side of things, so there is a dual notification for any reemployed retiree who's going to work for a public employer. And so they're required to notify the PERS staff within 10 business days of accepting employment in a PERS eligible position. Where this gets complicated is there's PERS eligible positions, there's non-PERS eligible positions, and then there's these few exemptions for elected officials or members of the Legislative Council Bureau, either House, the Assembly, or the Senate, senior judges, and this would add this for the commissioner members. The gaming commissioners. So it's complex because it's a start and stop, and it's a very complicated benefit calculation because there's different rules that apply, whether or not you come back. You have to be back at least 6 months in order to get a recalculation. If you're back less than 5 years, it's an additional benefit rather than the ability, and after 5 years, you have the ability to combine the benefits if you so choose. So there's just different provisions. So reemployments and the calculations that go into account with it are very complicated, but we are seeing more and more of individuals coming back and joining the workforce after a short stint in retirement. So I hope that answers your question, but if you have anything further, I'm here to assist.
Thank you for that. And yes, I think, it's retirement isn't what we all think it's going to be. You kind of get out there and you're like, wait, I'm too young to I need to do something. So with that, it also sounds like you're saying that this would actually just have those commissioners in line with a caveat that we already have
Yes, so
Okay.
under the current language and kind of in the draft, there's already that exemption for either House of the Legislature or the Legislative Council Bureau, and then also for senior judges. So it's just another little small subgroup, and the board was neutral on this because of the small group rather than opening it up to the masses, because that would have a significant cost associated with it.
Okay. That's helpful. Thank you so much.
All right, thank you.
Is there anyone else that would like to testify in neutral? Is there anyone in Las Vegas that would like to testify in neutral? Broadcasting, will you open the lines, please?
There are no callers at this time.
Thank you. Then I will welcome Mr. Hendrick back up if you would like to make any final words.
Thank you, Chairwoman Miller. Again, for the record, Kirk Hendrick. I just want to thank you again for allowing me to testify via video conferencing. Very much appreciated, so I could do that, and certainly mean no disrespect by not being in the room with you today, which I generally prefer to do. And also, I want to thank all the committee members for your attention, and we're always available to answer any questions you may have about this bill or anything regarding Nevada's gaming industry. Thank you.
Thank you so much, and we appreciate that. We all prefer in person, but we also love the benefits of technology enabling us to do multiple things in our day. So we appreciate it, and go have a great meeting. With that, I will go ahead and close the hearing on Senate Bill 14. Also would like to acknowledge Mr. Morton that's in the room, that we're happy to always see back in this building. With that, our next hearing is Senate Bill 39, and it will be presented by Marcy Reba. This measure provides that certain records received, obtained, and compiled by the Board on Indigent Defense Services in the Department of Indigent Defense Services and the Department are confidential under certain circumstances. Did I pronounce your name correctly?
You did.
Thank you. Okay. And your hearing's open, so please proceed when you're ready.
Thank you, Chair, members of the committee. Again, my name is Marcy Reba, RYBA, and I serve as the Executive Director of the Department of Indigent Defense Services. We are very excited to present Senate Bill 39 to you today. Just a little bit of background, as you may recall, we sit under a Board of Indigent Defense Services. In NRS 180.320, the legislature asked the board to establish minimum standards that our indigent defense providers have to comply with. They also asked that our board establish procedures to receive complaints and recommendations so that members of the community, judges, fellow attorneys, clients can write complaints or recommendations if they feel that maybe an attorney isn't necessarily complying with those minimum standards, or if they feel that there's issues that need to be addressed. And then with our department, we are supposed to develop resolutions or go and discuss those complaints with those attorneys. Part of the purpose of SB 39 before you in Section 1 is to provide that any of those complaints are confidential. We want to ensure that people feel comfortable to bring those complaints forward to us and address those issues. This is so important to our board that they also allow individuals to submit those complaints anonymously. But if we have that ability to contact the person that submits the complaints because they know that their name will remain confidential, maybe we'll get more feedback in our goal to try and make sure that these attorneys are complying with those minimum standards and addressing any issues that we're seeing in indigent defense. Excuse me, that's actually part 2. The first part is to have all records received by the board or the department to be protected, that are protected by the attorney-client privilege, to remain confidential, and I'll get more into that in Section 2 when we discuss that. And then finally, it does allow us that if in our discretion we need to communicate with a licensing board or other government agency that's investigating a complaint against an attorney, that we can cooperate with that. Again, we are not the bar. We do not step into the shoes of the bar. What we do is we try and address any sort of complaints that come up and just go and talk to that attorney to make sure that they're complying with minimum standards, or a slight reminder of what minimum standards are. So we don't take any steps to that the bar would take. It's just to make sure that these indigent defense services are complying with the minimum standards. Section 2 provides that there are certain records which need to be provided to the department. As you all may remember, we have a stipulated consent judgment with the ACLU where they brought a case, Davis v. State, and they've asked the department to collect certain information. Feedback that we've received from attorneys is that they feel that this is protected by the attorney-client privilege, so they haven't really wanted to provide that information that's required to be collected by the Davis stipulated consent judgment. With Section 2 of this Senate bill, it provides that that information remains confidential. We also recently had the law change where in NRS Chapter 7, when attorneys are requesting expert or investigator expenses, Instead of having to go through the judiciary, they can now submit those requests to the department. When you are submitting a request for an expert, we need to look at it to determine, is this a reasonable and necessary expert? So on the form, an attorney is required to say what they're thinking about the case, why they need this expert, and what they think the expert will show, so that we can review and approve those funds if appropriate. They also are required to submit their compensation expenses, and we need to review those as well to make sure that it's reasonable and necessary of what they're doing, looking at when they're contacting the client. And those bills may contain information which is protected by that attorney-client privilege. So with the creation of Section 2, it does protect that information. So if we get a request for that information, we do not need to turn it over because it is protected by that attorney-client privilege. And we are hoping that with these protections, that attorneys will be more open to providing that data that we are required to collect. And then finally, subsection 3 declares these records as confidential for public record requests. We want to ensure our public defenders that if they're sending us a request to try and hire an expert, that a prosecuting attorney can't just do a public records request and see what they're thinking about the case or see who they're hiring. So those are the 3 sections of the bill, and I'm available to answer any questions.
Thank you so much for your presentation. With that, we'll open it up for questions, and our first question is from Assemblywoman Cohen.
Thank you, Chair, and thank you for the presentation. So my question's about Section 1, Sub 3, the discretion language. I was a little, when I read it, it had me a little confused, or I guess concerned, because attorneys have an obligation to the bar, and I wanted to make sure that this wasn't superseding or trying to supersede that obligation, and I just want to make sure that we're clear that you still have that obligation to the bar and that obligation of, okay, so you're nodding your head, so yeah, so, okay, so I think maybe this, right, if you just want to kind of explain that a little, so we've got that clear on the record.
Thank you, Assemblywoman. Deputy Director Tom Qualls, QUALLS, for the record. Yes, that's exactly, I think, what the subsection 3 there is designed to do, is to sort of codify that we do have the obligation to cooperate with the with the bar or any other professional organizations regarding these complaints that would otherwise be confidential under this section.
Well, and and like I said, it's a little confusing because it does say.
Do you need a follow-up?
Sure, follow-up, please.
Go ahead.
It does say at its discretion, so that's the language that does confuse me, that it makes it sound like the board has discretion as opposed to is required to follow the requirements of the bar that all attorneys are required to follow.
Correct. And there may be, I don't know if there's some splitting hairs here or not, but it's also that a complaint to our department is not the same thing as a complaint to the state bar. And wherever we receive those, that's part of the communication that we give back in return. So it's our understanding ethically that if we have personal knowledge of misconduct of another attorney or a judge, that we have an obligation to report that. But secondhand complaints, I don't think, rise to the level of us having personal knowledge either.
Follow-up, please.
This will be the last one.
Okay, but so to be clear, that discretion, though, still does not, I guess I'm just, it's the way it's drafted that it says it doesn't prohibit the board or the department at its discretion from communicating or cooperating with or providing any records to any professional licensing board, where to me that almost makes it sound like it's your choice, whereas under the rules that attorneys follow, you're obligated to you're obligated to provide that information to the bar if you have the firsthand knowledge. It's not discretionary.
Thank you. So I think that the purpose of the complaints and recommendations portal is for individuals to let us know whether attorneys are following minimum standards that have been established by the board. These minimum standards aren't necessarily adopted by the bar in something where they could take steps to look at whether or not you're in compliance. You know, these arise to whether or not you're communicating with the client within 7 days, or whether or not you're making bail hearings at certain hearings. The purpose of these complaints is to make sure that these minimum standards are being followed. If there is a complaint that arises to the level where it needs to be referred to the bar, we generally do encourage the client or the person that is making those complaints of the process to be able to do that, and we would cooperate in those proceedings if we had that knowledge. So I think we don't want to misrepresent what the purpose of these complaints and recommendations are, because they are, again, solely around indigent defense services, what our board is looking at to make sure that they are in compliance. And these may be things that the bar doesn't necessarily regulate or look at, you know, those specific minimum standards, because they apply to our indigent defense providers, but they may not provide to or apply to a civil attorney. Add something?
Chair, if I could just add to that. Tom Qualls for the record again. And again, I would say that the only distinction there is that this section governs complaints that come to our office for which we don't have any personal knowledge. I think the personal knowledge requirement for us reporting to the bar would supersede this. I think that's the distinction, and the specificity of this is that this is about complaints coming into our office that we don't have personal firsthand knowledge of.
Okay, thank you.
Thank you. Our next question will be from Assemblywoman Mosca.
Thank you, Chair, and thank you for this. While I was reading this, it made me think to ask, how many complaints are you getting? Is this out of a genesis of you're getting a lot of complaints and now you need to have it set up, or is it because of that court case that you had referenced as well?
The volume of complaints is, I'm sorry, Tom Qualls for the record. The volume of complaints is not very high at this point. We do get 1 or 2 a week generally, and address those. And the primary reason that this was drafted to begin with had to do with the reporting requirements. We're required under Davis and under the regulations to collect certain data from all of our indigent defense providers about the numbers and types of cases and what they're doing in those cases. And there was, in the beginning when we rolled out this case management system to collect that data, because we have access to every office's case management system, there was concern that conscientious attorneys didn't want to be subjecting that information to a third party, which would breach confidentiality. So that was the primary reason for doing this, was to ensure that whatever came into our office, whatever we had access to, remained confidential. And then the complaint part was sort of an add-on that has taken up more language than the original intent, but it was sort of just to cover all of the bases.
Thank you. Our next question is from Assemblywoman Summers Armstrong.
Thank you, Madam Chair, and thank you for this presentation. So I'm always a little bit taken aback when I hear that there's been a court case that requires something, and then people decide that they're not going to comply, which is, I think, what I'm hearing you say about the ACLU case and about submitting information. And so can you explain, like, how does that happen? How do we just not do anything?
Tom Qualls for the record. Thank you, Assemblywoman, for your question. It's my understanding in talking with these attorneys when we were rolling out this process that this is almost like a law school ethics question, right? So the ACLU lawsuit and now our regulations require the collecting of this, but there were attorneys who felt that there were aspects of this legal requirement that also required them to potentially violate their ethical duties or their duty to their client as far as confidentiality. So you've got this tension between the two. That, in essence, is the genesis of this bill draft, which is to try to make sure that they could comply with the requirements of the law and of the Davis settlement, as well as their ethical obligations to their attorney. The attorney-client privilege is considered sacrosanct in indigent defense. And so it's just to make sure that those two things are not mutually exclusive and that they can coexist comfortably.
Please proceed.
So when these attorneys were having this this conflict of conscience, did they get permission from any judicial branch or any judge or court that said that they could wait to provide this information until this was determined? And if they didn't, what was the penalty for basically ignoring a court order?
There's not any, there wasn't any judicial permission for their hesitancy. I can say that all of them, all of the offices, all of the contracts, all of them are cooperating and reporting all of this information now. We did do some extensive research on this, including consulting with the AG's office as well as ethics professors at UNLV Boyd. And this was the path that we took in order to, again, ensure that these two things could coexist. But in the meantime, they have been complying. So it isn't that there are any attorneys out there right now just refusing to comply with this legal requirement. But it was a conversation that we had in the beginning.
Proceed.
Thank you. I just find it sickeningly, I think, hilarious that nobody else gets to do this, right? That regular people, we have to follow regulations and laws that are set by this legislative body that the court hands down, and we don't get to have a conflict of conscience when we are required to follow the law. And there's always, for us, especially people in the community that I represent, when we don't comply. But because folks have a JD behind their name, they can play around and skirt around the edges about what they comply with and what they don't. Under these sort of, it just gets on my nerves. And I think that it's disingenuous that here we are, you know, having discretion about how we report people's behavior. I think that's also a little bit disingenuous. If somebody isn't representing their client, they should be reported. If they're not following a court order, they should be reported, because nobody else gets to get away with this. And it's really, really frustrating. I understand what you all are trying to accomplish here, but nobody, if they don't, whether they have a JD behind their name or not, should have a better position to skirt around the edges than I do, because I don't have one. And I'm just, the gall, it gets on my nerves. But thank you, and I will give this due consideration.
No response. Maybe I I would like to ask the question again. Can you just clarify again in 2 or 3 sentences what the issue that's trying to be resolved is? So that about the client privilege and the legal, and I feel it's more than just even legal. It literally is fundamental to our system, our legal system. But what in that case and the conflict that with the attorneys as they're trying to comply, but they already have an additional, and I'll say foremost obligation for attorney-client privilege. And, this is often discussed in the Education Committee about data collection. And again, privacy versus information. So could you respond to that in maybe just a few sentences?
Thank you, Chair Miller. Tom Qualls for the record again. In a nutshell, I would say that to an attorney, attorney-client privilege is sacrosanct. It's of the highest importance. And if a law is passed that infringes upon that, I think that most attorneys would say that their first obligation is to their client and to the confidentiality. And there are many attorneys who would risk contempt charges to protect that. That was the nature of the complaint, was that exposing this data to a third party, namely our department, could potentially cause them to waive that confidentiality. And so this statute, in its origin, this bill was designed to make sure that we were protecting that primary obligation of the attorneys while they were complying with the requirements of Davis.
And Chair, may I just add, the other purposes of the bill is we want to put our indigent defense providers on the same step as prosecutors. When prosecutors have their budgets built, they have budgets for experts and investigators, and they can go and retain those experts and investigators and not have to tell anyone. We are heavily reliant in Nevada on appointed counsel, so they don't have separate budgets from the county to be able to go and hire experts and investigators. And most public defender offices, including the Nevada State Public Defender, we don't have a budget at all to be able to provide experts and investigators. So that means that for our attorneys to be able to access these funds for experts and investigators, they need to apply to a separate department and set out, what is my thinking with this case? Why is this necessary? And why should we spend public funds on this expert and investigator? Then a separate entity, generally us, reviews it to make sure that it's appropriate to hire. So we want to ensure that that information remains confidential, that a prosecutor can't just do a public records request to us and say, I would like to have a copy of all expert investigator requests made by this attorney. So we want to make sure that those thoughts of that attorney, the reason that they're hiring these experts and investigators, is confidential and remains confidential, because the prosecutor doesn't have to come to us to ask for funds. They have those funds in their budget. But a defense attorney does, because we're so reliant on so many individual attorneys. So that is that main part of the purpose there. And we also want to make sure that people are comfortable in bringing complaints to us. Sometimes clients may not want to tell the name of themselves because they don't want anything to happen to them with their attorney. Or maybe a judge doesn't want it to be known that their name is the one making the complaint. But in the end, what we're all looking for is, we want to make sure that these minimum standards are being complied with for our attorneys, and we want to make sure that these attorneys have access to the same resources as our prosecutors, and that we keep that information just as confidential as it would be if they had been in that prosecutor's office.
Thank you for that. And my additional question to that is, because you do reference the lawsuit from the ACLU, have you had any kind of communication with them regarding this bill?
Thank you, Chair. Marcy Reba for the record. Yes, I have reached out to the ACLU. I believe that they were in support of it at the last hearing in front of the Senate. So I have talked to them about this bill, and they believe that It is important to have that separation from the judiciary, where it was previously, where the judiciary would review these claims. And it's also important for us to be able to collect the data that we're required to collect, and that we can process those claims for compensation or those expert requests. So I believe that they did testify in support of it at the Senate hearing.
Okay, thank you for that. Our next question is from Assemblywoman Newby.
Thank you, Madam Chairwoman. Thank you for this bill. I had a question regarding the interaction and the complaint process vis-a-vis the state bar. And I bring it up because I think most of the clients probably wouldn't necessarily think that the place where they would go to complain about their service would be your department. They would, I think, more likely think you bring something to the bar. And so I was wondering if there, similarly to reporting or communication between DIDS and the bar, is there another communication between the bar to DIDS if, say, a client makes a complaint to the bar, it doesn't quite reach the level of what a bar complaint should be. It doesn't really qualify, but it's still a service issue. Would the bar then notify you about the complaint in terms of service of that attorney so that you could take it on as the contractor?
Thank you, Assemblywoman. Tom Qualls for the record. There is not a process in place right now for that information to come from to us from the bar. It's an interesting conversation that you bring up that we should have with the bar. I don't know what the bar's confidentiality requirements are regarding that, and whether they would be open to, or if they are able to open to share that with us, but there's not a process for that right now.
Thank you for that. Our next question is from Assemblywoman Considine.
Thank you, Madam Chair. Thank you for this bill. My question is along the same lines of both of my colleagues. You'd mentioned earlier about a secondhand complaint, and I guess I'm just looking for some clarification on that. I understand if there is a client who calls your office or contacts you to complain because they feel that their attorney isn't communicating with them in a way that they want to communicate with them. And in that respect, it's potentially a training issue, more of a personnel issue between them that wouldn't rise to a level of alerting the state bar. But if it's a breach of ethics, if it's a client who says, you know, the attorney didn't show up at my hearing, or the attorney showed up and was, obviously on something and didn't do anything for my trial, or something that breaches that ethic requirement, or the responsibility of an attorney who is barred by the state. In those situations, is there an alert to the state bar, or is there a conversation with the client about their ability to file a complaint with the state bar? I just want to make sure that there's like a clarification of what you mean by secondhand complaint and knowing and not knowing in that context. Thank you.
Sure. Thank you for your question. Tom Qualls for the record. I'm speaking about this sort of like from an evidentiary standpoint in court, in which one either has firsthand personal knowledge, they witnessed it, they're aware of it firsthand, personally, eyewitness or otherwise, versus that information coming from a second or third source, in which it would be, and again, legal terminology, hearsay, but it wouldn't be something that we had personal knowledge of. So that's the first distinction. If we get a complaint on paper, even alleging an ethical violation, it's not something that we still witnessed or have firsthand knowledge of. We have secondhand knowledge of that. And then the second part of the answer is that we are careful when we communicate back to the client or whoever the complainer is to explain our role in sort of overseeing the systemic processes and the individual attorneys versus the function of the state bar, or potentially a petition for writ of habeas corpus alleging ineffective assistance of counsel. Those are two different avenues that are available to any criminal defendant. And so we make sure that we lay those out and communicate that to whoever is complained to say, we will address this in this way, and we are not the bar, and we're not, a court of law, and these are your other options. If you feel that the performance has fallen below a reasonableness standard, if you believe that you've been provided ineffective assistance, or if you think that there's an ethical obligation, these are the paths that you must take.
Thank you. So this just leads to my next question. When you're working with those clients, is there an agreement that a client has to read or agree to, or a contract between this department and the client, or is that left to the attorney representing the client? And in that agreement would be the information if they were had an issue or something, the steps that they could do. Is that through you, or is that just left up to the attorney actually directly representing the client?
Tom Qualls for the record. Can you clarify your question? I'm not sure I understand it, sorry.
Yes, so typically in a retainer agreement or some sort of an agreement between the attorney and the client, information in that would be if you were unhappy with the service, what you are to do. I guess what I'm trying to figure out is there anything in writing or notification given to the clients through your office, or is that left to the attorney that is directly representing that client?
That any type of agreement like that would be between the client and the attorney. We have no attorney-client relationship with the clients, and in fact, we always state that we're not permitted to give them legal advice because they're represented at the time. We also have notice on the website of what I was saying about that we're not the state bar, et cetera. So yeah, that would be between the attorney and the client.
Thank you for that. Not seeing any additional questions right now, I would like to open it up for testimony in support of SB 39, beginning here in Carson City.
Good morning, Chair, members of the committee. Erica Roth, ERICAROTH, on behalf of the Washoe County Public Defender's Office, testifying in support. I want to clarify a few things. I think that there might be some kind of misconception about what complaints we're really talking about and why it's so important that this bill keeps this communication confidential. So prior to DIDs being formed, if a private attorney or a conflict attorney, a panel attorney, was requesting funds for an investigator, they would file a motion under seal with the court. And it's that kind of information that we want to keep confidential because it's now going to DIDs instead of a judge. And it's to ensure that the information that's provided in that motion, for example, that lays out why an investigator is so important to a case. Facts about a case that we don't want to pass over to a district attorney, our theory of the case that we don't want to pass over to the district attorney prior to trial. So we need to make sure that that information is kept confidential because now those requests, instead of being filed under seal, are going to DIDs. It's also important, is for the benefit of the client, that if a client makes a complaint against their attorney, it is inevitable that that complaint is going to contain facts about their case that also need to be kept confidential from the prosecuting attorney. So when we say that a prosecuting attorney is having a conflict between the ethics, the law of the ethics that binds them to ensure that they do not disclose any confidential communication between them and their client, that is sacrosanct. We're ensuring that if a complaint against that attorney doesn't mean that there's no repercussions, right? Its insurance is for the benefit of the person making that complaint, that information is not now subject to a public records request, is not available to the prosecution, and could somehow be a detriment to their case. So it's for the benefit of the person making that complaint. It doesn't mean that that complaint doesn't go to the state bar. It doesn't mean that there's not repercussions if they fall behind on their case. There's already legal mechanisms put in place with ineffective assistance of counsel claims, but it's to ensure that that confidentiality remains intact now that we do have this new system with DID set up. This bill is essential to that. It is essential. It is a benefit to the clients, to indigent defense services, and I really urge your support. Thank you.
Thank you, Madam Chair. John Puro from the Clark County Public Defender's Office. I do want to echo the comments of my colleague, Ms. Roth, from the North. The Department of Indigent Defense Services exists because Nevada was doing such a terrible job with defense in the rural parts of the state. And they're here to organize us, get us on the same page, make sure that people in Elko and Ely get the same type of defense that people in Clark and Washoe are receiving. One of the things that's most important with our job that the United States Supreme Court and the Nevada Supreme Court have recognized is that attorney-client privilege is one of the bedrock principles of our job. It allows us to communicate with our clients in an honest fashion and our clients to communicate with us in an honest fashion. A savvy prosecutor may use a FOIA request to get documents from the Department of Indigent Defense because they are a public agency. What this bill seeks to do is to protect those documents. As Ms. Roth has said, when I am formulating investigation requests, I have to send those through my supervisor. The rural attorneys have to send them through the Department of Indigent Defense. Oftentimes, I have to justify why I want this expense, whether it be an expert or we're going out and doing a site visit or whatever we're tending to do. So I will put case strategy in that request or any communication between me and my investigator personally. We do not want that discoverable by the prosecution. That's why this bill is necessary. So I think some of the presentation went off the rails just a little bit, but just trying to rein it in and say, like, this is the purpose of that bill, and that's why these things should be protected by the attorney-client privilege and not discoverable by the prosecution.
Thank you so much. If you both could just wait a moment. Members, I will open it up if you have any questions for the public defenders. Assemblywoman Hanson.
Thank you, Madam Chair, for that opportunity. Thank you for coming to the table to clarify. Just what you were saying, Mr. Piro, regarding the rurals. You said that historically they had to put the request in. If you could just kind of reiterate it again. It sounded like there's a different process that existed for the rurals versus maybe other areas. Is that what you were getting at? That it has to go through the indigent defense? And so just clarify that one more time for me on the record, because I was taking notes when you were clarifying it.
So previously, and this was true in the rural counties and the urban counties, is that prior to the Department of Indigent Defense, the request would go through the county. But now the state is now funding these services, and so now that request goes to DIDS, who oversees this. But previously, that request would be filed under seal with the court. And so a defense attorney would draft a motion that would not be available to the prosecution, and that motion would have to include facts and theory of the case, your theory of defense, why you needed an investigator, funds for an investigator to find certain evidence or to hire an expert witness. And it's sacrosanct. It is essential. It is the bedrock that information is not provided to the prosecuting attorney prior to trial. And so all this does is ensure that what was previously filed under seal with the court and funded by the county, because it's now funded through DIDS with the state, that same request with that same information still remains confidential and is not subject to any public records request or any formal request.
Madam Chair?
Yes, please.
Thank you. That really helps to clarify. So thank you for that.
Thank you. Our next question will be from Assemblywoman Summers Armstrong.
Thank you. I appreciate the clarification, and I absolutely understand the attorney-client privilege and that part of it. but my understanding from the testimony was that there was a lawsuit. ACLU required certain information to be gathered, right? That information was supposed to be kept someplace, right? Collected and kept someplace. So I understand the confidentiality portion of it. I guess what I'm just kind of struggling with, and I appreciate your clarification. I get it. I guess my question is, for the information that was supposed to be provided, if the portal gave them pause, do you just not provide the information that was required by the lawsuit? Or do you ask the judge, is that the appropriate thing to ask the judge if we can collect it but hold it until we can get this cleared up about the portal and whether or not it's discoverable, or whether or not it can be, that the portal is secure, right? So that this data isn't released. So is that completely different from where we're talking about the investigation, or are they all one and the same?
John Piro for the record. I think this question would probably be most appropriate for Ms. Reba from the Department of Indigent Defense Services, but I do think there's two separate issues that we're talking about here. The confidentiality issue to defend kind of what is going on in our investigation and making sure that that's not disclosed to the prosecution, and the parameters that we need to meet to deal with the consent decree from the ACLU lawsuit. And I don't think that they conflict in this bill. Like, I don't think the ACLU and the court will not be able to get the information that they need to say, hey, we're actually fixing indigent defense services and the rules. I don't think the confidentiality provisions are going to prevent that part of it.
Thank you. Our next question is from Assemblywoman Mosca.
Thank you, Chair. Thanks for coming up. Just a quick question. Has this happened before, or is this being proactive? Like, has somebody asked for the public records request?
John Piro for the record. This is a proactive measure to protect, because now we are in a new state of being with a public agency. Prior to this, you would have to go through the county to get your information, or through a judge. And what we've been trying to do is insulate the attorney-client relationship from interference by the judiciary or the larger county, to give those rural attorneys that are providing indigent defense services some manner of independence, but supported by the Department of Indigent Defense Services.
Thank you for that. Members, are there any additional questions? Okay, thank you. Again, we always appreciate it when people are able to come up and just respond in an impromptu manner, but thank you so much for that clarification. With that, is there anyone else here in Carson City that would like to testify in support of Senate Bill 39? Not seeing anyone. Is there anyone there in Las Vegas? Also not seeing anyone. Broadcasting, will you open the lines, please?
To provide testimony in support of Senate Bill 39, please press star 9 now to take your place in the queue. There are no callers choosing to provide testimony in support at this time.
Thank you for that. Then I will open it up for opposition testimony. Is there anyone here in Carson City that would like to testify in opposition of Senate Bill 39? Not seeing anyone. Is there anyone there in Las Vegas? Is there anyone there in Las Vegas? Okay, I don't believe there's anyone there. Broadcasting, will you open the lines for Senate Bill 39 for opposition testimony?
To testify in opposition to the Senate Bill 39, please press star 9 now to take your place in the queue. There are no callers choosing to testify in opposition at this time.
Is there anyone here in Carson City that would like to testify in neutral? Not seeing anyone. Is there anyone there in I know there's no one. Broadcasting, will you please open the lines for neutral testimony.
To testify in neutral to Senate Bill 39, please press star 9 now to take your place in the queue. There are no callers choosing to testify in neutral at this time.
Thank you so much. Then I will welcome our presenters back to make any final remarks.
Marcy Reba, for the record, I just want to thank this committee for taking the time to listen to this bill. And I'd like to close with one of the biggest issues we've had is that change is hard. Change is hard for rural attorneys that haven't had to report time or to give information that we're asking them to give at this point in time. So the purpose of this bill is to ensure those attorneys that we are protecting the information that they're giving them, that even though they go through us, it is still protected by that attorney-client privilege, so they can provide that data so that we can comply with our lawsuit. And the reason that this is so important is in those rural counties, they don't provide their indigent defense attorneys with a pool of funds to be able to provide experts and investigators. That's budgeted, but it's not necessarily budgeted exclusively for that one attorney. So we provide a process so that they can be able to access those funds. And we want them to know that if they let us know their theme and theory of the case, that that's going to be protected from anyone doing a public records request to see what's going on in the case. We are always available for any questions that you may have on this. So if you have anything further for us, please let us know and we'd be happy to answer any questions. Thank you.
Thank you so much for that. I will go ahead and close the hearing on Senate Bill 39. Next up, we have Senate Bill 63. Senate Bill 63 revises provisions relating to the Judicial Department of State Government. This will be presented by John McCormick, Administrative Office from the Administrative Office of the Courts. And with that, Mr. McCormick, your bill hearing is open, so please proceed when you're ready. There's no rush. We know it takes a few minutes sometimes to get yourself settled and ready, so take your time.
Thank you, Madam Chair, members of the committee. My name is John McCormick, John, last name McCormick, the Assistant Court Administrator at the Administrative Office of the Courts. And as indicated, I'm here today to talk about the first reprint of Senate Bill 63, which is does a lot of modernization and cleanup in some of the initial chapters of NRS dealing with the judicial branch, and as well as a fix in Chapter 281. With the committee's indulgence, I'll do a quick attempt a quick run through the sections of the bill. Section 1 modernizes language regarding making the contact information of courts available. It's just that it must be made available to the public, not that the phone number must be published in the phone book. So it's just updating that language.
Mr. McCormick, could you please define phone book for our younger members?
John McCormick, for the record. Back in the day, I hear there was a book that the phone company that had multiple sections, one for business, one for regular people, put together and gave to everybody so they had it at their house. Now we use the internet, so we want to put the phone number on the internet, not a non-existent book.
Okay, thank you.
So, thank you. Again, John McCormick for the record. Section 2 modernizes the language around holding court during emergencies. While I personally am very fond of the phrase war, pestilence, or other public calamity, we thought that perhaps was a bit antiquated and just are cleaning that up to, in case of public emergency, court may be held away from the county seat. Section 3 is a technical cleanup and adds location in addition to place where court can be held, just to make sure that's broad enough to handle modern technology, remote appearances, etc. Section 4, this is another old-timey section, dare I say. Currently, court proceedings must be open to the public, but minors can be excluded unless the minor is a party to the case, obviously. So, you know, if the child has some interest in the case, they can go in. Or current statute is a minor who is studying to get to become licensed for law. So in that case, with the way law licensure happens in this state, I think that person would have to start college at age 10 to comply with that, just age-wise, because obviously you have to have a 4-year degree, then a 3-year degree, and then take the bar to pass. So we're just removing that antiquated language that prevented the court from excluding minors who are studying to be lawyers from proceedings. Section 5, as I think I probably indicated before, the AOC is currently working on a statewide e-file system, and in order to effectuate that, this just updates the language and requires the Supreme Court to have appropriate rules for e-filing in this state. Section 6 updates with courts must be open to take filings for protection orders 24/7, and this just updates that it can be electronic communication, as we're working on a public portal to allow that application rather than just phone calls. So again, it's a modernization piece there in Section 6. Section 7 is another modernization piece about possession of the court seal, because the court seal is more of a concept now. You can electronically seal. However all that works, I'm not going to try to explain IT stuff I don't know. But it modernizes that language. Section 8, this was a section that we amended in the other house, and it deals with disqualification of judges. Currently, what can happen is a person, if they want to disqualify a judge assigned to their particular case, they're allowed to file an affidavit to make that request. And this keeps that provision the same and governed by statute, but it does add in that the request for disqualification must not be filed to interpose delay, to harass a judge, for those sort of bad faith purposes, because what we've experienced, particularly in the 8th Judicial District Court, are serial disqualifiers who try to disqualify the entire bench to stretch out their criminal prosecution. So this just requires that those disqualifications, that they attest they're being made in good faith. And it also clarifies when affidavit for disqualification is filed, the judge who is subject of the request has an ability to respond to that. Like, I don't like Judge A, I say Judge A can't be fair. Judge A has a chance to say, no, I can be fair for these reasons. And this changes the time frame on that from when the judge who is subject to the request is served rather than when it's filed. So the judge has adequate time to assess the request and make sure if they need to file that reply or however it's going to be handled. Section 9 modernizes language regarding the duties of the state court administrator, and just takes out some antiquated references. Section 10, and you'll see this throughout, there's several sections, that changes requiring the AOC to make regulations into rules, because courts, on the court side, we tend to make rules, we don't make regulations, and that just is a language difference that was important for us to ask to put in statute. Section 11 modernizes language on interpreter fees. So the fee that we suggest courts pay to use the services of interpreters, and just by way of kind of a news note, that our guideline recommendation was recently up to $49 an hour from 25, which puts us commensurate with a lot of other states. Section 12, again, modernizes language regarding that interpreter program. Again, recognizing the court makes rules, not regulations, the same as Section 13. Section 14 updates the language in the statute around interpreters to use the term limited English proficiency, which is the preferred terminology for that we use in the court system when a person requires interpretation services. And it also allows the court administrator to appoint a vice chair of the statutory advisory committee regarding court interpreter program. Section 15 is another regulation to rule section. Excuse me. And Section 16, again, replaces the statutory procedure for how a person may challenge. So we do interpreter certification. So an individual has to take a written workshop or take a workshop, pass a written test, then pass a 3-part oral examination to get their certification. And then after that, they're subject to a background check. And currently, there's a statutory procedure to contest that if a result on the background check comes up that would be disqualifying. And this bill puts that into rule. We've, I think, had that situation maybe once or twice, generally, where something has come up on a background check and the court administrator reviews that, and I don't believe we've ever denied anyone certification based on that. Section 17 clarifies when an appointed judge, a judge who's appointed to fill a vacancy, when their term begins and ends. That has been, and had some confusion around it, and there's some court cases, so this just is further clarification on that, hopefully to get statute updated there so it's more clear to everyone. Section 18 removes the statutory requirement for the effective date of court rules. That court does that on their own procedures. They don't make rules saying, here's the new rule and it's effective tomorrow. It's almost always 30 days, but it removes that statutory requirement in the event we do have sort of an emergent situation. For example, last fall, I think we put in a rule that deals with a child welfare issue that should have been in statute, but going in rule was the only place. So like an emergent rule, you would have that become effective a little quicker than, say, otherwise. Section 19 clarifies that it's the state's responsibility to fund the Supreme Court. This is, again, an old-timey statute that said the court could order the sheriff to provide them with a place to hold court. And as much as I think Sheriff Furlong would enjoy getting drug into the middle of that, I think we want to clarify that and just make that clear. Section 20 modernizes language around the use of digital signatures. Now that's becoming more commonplace, and you've got the whole chain to prove that it really is who signed it. Section 21 modernizes language regarding the clerk of the Supreme Court who serves at the pleasure of the court. This was actually, it looks like a statute that is a creature of its time because it dealt with someone who was appointed to the position before January 1st of 1957. So we're removing that old reference and just, again, sort of trying to clean up that section. Section 22 removes unnecessary language regarding the employment of bailiffs or marshals at the Supreme Court. That's the same thing that Section 23 does. Section 24 modernizes language regarding court employees to reflect the purpose of staff in our modern state. Section 5 changes, Section 25, sorry, I'm confusing myself, changes some shalls to must regarding the law library. So again, it's a modernization of language. Section 26, again, it's a page-long section to remove regulations from the statute. Section 27, this is probably the most popular section of this bill, if I can make that assessment. And what Section 27 does is clarifies the responsibility of the county in terms of providing resources for the district court. And we spent a bit of time working on this with particularly the 8th Judicial District Court and Clark County to get this to a place that everyone's comfortable with. You will note that there was an amendment I submitted yesterday that further clarifies this language in subsection 4, just reiterating that the county is responsible for providing suitable and sufficient resources to the court to perform its constitutionally mandated duties. And then also, I would like to point out in subsection 3 of Section 27, the provision says that the county commission can require district courts to expend money appropriated for a specific purpose. The purpose of this section is to clarify that, say, the county commission gives a judicial district money to buy computers, for example, to modernize, get ready for e-filing, whatever, that the court can't then, because that's a special appropriation for that purpose, the court can't send then, no, we're not going to buy computers, we're going to buy telephone books, you know, there, to try to bring that back. So that's the intent of that subsection 3 of section 27 there, is just to clarify that when there's a specific appropriation made, that it should be used for the purpose for which it's made, and it doesn't necessarily apply to the regular operating budget of the court. All right, we've got section 28 now. Again, it removes regulations, as does 29, as does 30. So section 30.5, this is a section that we worked on in the other house at the request of the chair, and what it does is it replicates the provisions regarding full faith and credit for protection orders that currently exist in Chapter 33 for domestic violence protection orders. It takes those provisions and replicates them for our high-risk protection orders, so the red flag orders. You may be more familiar with that term. And this language we did in cooperation with the Metropolitan Police Department, just to ensure that they have all the tools they need when we do have encounter a situation where a high-risk order is needed. And also, as more states develop their own high-risk order process, this provides a statutory framework for recognizing an order from another state in that same manner. Section 31, again, is a replace telephone with electronic means section. So, yeah, again, that's 4 pages of bill for about 4 or 5 changes of telephone to electronic. Then we have sections 32, 33, 34, all change regulation to rule, again, as has been consistent throughout the bill. Section 35 removes a reference to 5 justices of the Supreme Court in Chapter 281, because before, I think 1997, it was a 5-justice court, then 2 were added, and then actually, well, no one wants this digression, and I won't waste your time with it. But suffice it to say, the court stayed at 7 justices, and so we just want statute to conform and just put justices of the Supreme Court, being that this body obviously has the constitutional authority to increase that number as they see fit. Finally, this bill repeals a few sections. One section dealing with adjournment in the absence of a judge, which is no longer antiquated. It's like if the judge isn't in the county and this is what you do to stop court. So that's not really a thing that we have encounter anymore. Also removes a section dealing with what the court seal is and how you procure the physical stamp. So probably don't need that anymore, being that obviously it's modernization. Custody of the seal, again, it's kept with the court. Documents to which a seal may be affixed, again, the court applies the seal to documents filed with it. Qualifications of the clerk of the Supreme Court, it again cleans that up. Authorization to apply deputy clerks, again, that's another cleanup. Also, our clerk of the court appreciates that she will no longer be fined $1,000 if she violates some of these statutes. I say that somewhat kiddingly, but it removes the $1,000 penalty for the clerk of the Supreme Court, basically, if they charge unnecessary fees, which is obviously not something that would be done. Also, it removes NRS 2.270, which allowed the clerk of the Supreme Court to destroy evidence, which I always thought was an interesting provision because the Supreme Court is an appellate court and generally does not receive nor store evidence. So it removes, again, that antiquated provision. It also removes the specific provision requiring the law library to be open to the public because the law library is part of the Supreme Court. It's open when our building is open from 8 to 5. The public may talk to library staff, access it at other times by special arrangement. We'll work that out with Marshall. So again, it's just cleaning that up. And then it also cleans up the qualifications of the law library and no longer requires the law library to make a biennial report to the Supreme Court because the law librarian is a department head within the court and regularly communicates with the court regarding library issues. So that is an attempt at a quick overview of this bill, and I'm happy to answer questions.
Thank you so much, Mr. McCormick. We do have a few questions. We will begin with Assemblywoman Newby.
Thank you, Madam Chairwoman. On section 27 of this bill, your most popular section, my question is, I have subsection 4 and subsection 5. If the county disagrees with some request for funding or some thing that the district court wants, Section 4 says that the court can order them to pay for it anyway. But then Section 5 says you can't actually take any money out unless it's been appropriated by the Board of County Commissioners in accordance with the budgeting process, which is a very specific and time restricted process. So I'm wondering about the conflict or seemingly conflict between those two sections.
Thank you. John McCormick for the record. So this is where we get into sort of that delicate balance under Article 3, Section 1 of the Nevada Constitution as far as separation of powers. The intent of Section 4 is to say that if the county refuses to provide the court the resources that are suitable and sufficient to perform its constitutional functions, and that's why we're offering the amendment to clarify that, then it can be ordered. If it's a disagreement, say about, I'll just use the computer example, we want 10 computers, the county only wants to pay for 5, that's what we do in the budget process. And unless the court determines, pursuant to the existing case law, that that denial is sufficient to inhibit its ability to carry out its core constitutional function, that's the only time the ordering comes into play. It's not intended to be like, well, if you don't give us the appropriation for what we want, we'll order it. It's like, we do the budgeting process, and then you get to the crisis point where, say, the county just is like, no, we're not going to give you any staff, for example. That would be when the ordering comes into play, because the absence of staff would inhibit the court's ability to carry out its core constitutional functions of deciding cases in a timely manner. But those other sort of budgetary enhancement type situations I don't think would necessarily fall under this, and that's consistent with the case law in the state, and that's why we worked quite a bit with Clark County to, in particular, to tweak this language and get it to their satisfaction where it reflects the existing case law, and that, for lack of a better term, that ordering, the court ordering the county to do something is the nuclear option, and nobody ever wants to get there, but this mirrors case law in statute. I hope that sort of rambling answer helped.
Did that answer your question, Assemblywoman? Yes, ma'am. Thank you. Next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, and thank you for presenting on this. My question is similar. I think you're probably not surprised that we are all asking about, or at least so far asking about that section. So I'm from Washoe. Second Judicial has an aging building. There is radon in the basement. There was an open sewer issue. There's mold and flooding. They've literally run out of room for their clerks and their filing staff. So would that rise to the level where under this they could say, we need a new building because we literally can't function in this one anymore?
Thank you. John McCormick for the record. That becomes a determination that has to be made by the chief judge and the members of that bench in their negotiations with the county. That's something, potentially, it could rise to that level. But again, that would ultimately, if it rises to that level, that's provided in our case law, and this statute would just match the case law. So I don't necessarily know that this statute would impact the calculation made by the court or the county in those budgetary discussions. Because again, that would be the nuclear option, and I don't think anybody on the Washoe County Commission or the Second Judicial District would particularly be excited about that.
Thank you so much. Our next question is from Assemblywoman Cohen.
Thank you, Chair, and if it's okay if I can have two
They're from two sides of the bill, the two different ends.
Well, if there are two sides, why don't we ask the first one, because there's other people waiting for second questions as well.
Okay, so I do have a question about let's start at the end, the high risk. So that's section 30.5, the high risk behavioral orders. Is the adverse party given notice of the order? Because they could be coming from another state. They know about it in the other state, but do they know that it's following them to this state?
Thank you. John McCormick for the record. Yeah, in subsection 1, sub B, the court has to determine that the adverse party was given reasonable notice and an opportunity to be heard before the order was issued in order for that order to become effective in Nevada. Sorry, I was just getting caught on the amount of times I was saying order. But in allowing full faith and credit, that assessment has to be made that the adverse party received sufficient notice on the state, in the state of origin.
Okay, follow-up though, but that didn't answer my question.
Certainly.
Okay, but I meant, right, I get that from that state, but the way I had read that, and I did read it late last night, so forgive me if I'm wrong, but I'm talking about that they know that it's following them to this state. So are they getting do they understand, or are they made aware that it's now still in this state, not just in the old state, the original state?
Thank you. John McCormick for the record. Again, I don't believe that requirement is in here, and it doesn't exist for the current protection orders when they come over from another state.
Okay, thank you.
Thank you. We're going to go back to Assemblywoman Newby.
Thank you, Madam Chairwoman. I guess my question still is around, the accoutrements for the courts, and how do those negotiations work if a county believes that the request by the district court is unreasonable or maybe out of line or not necessary? If you could just go into that a little bit more. Thanks.
Thank you for the record, John McCormick. Not necessarily speaking to any specific county process, but my understanding was it would be similar to sort of any budget process. The court comes with the budget request, the county has a concern about some item in there, and then however those negotiations happen between the county personnel and the court at that level. Because just like how the Supreme Court comes to the legislature, for our operating budget, it's the same thing. And so it just becomes a give and take and a negotiation. Generally, the only times we've ever seen something rise to the we're going to order you level have been particularly difficult situations. Thinking about 3 in particular where the situation was in one, a municipality wanted to control individual staff members of the court, set their pay and tell them what their job duties were. That rose to a case. There was another one where the district court made a request it considered reasonable regarding employing juvenile probation officers, and the county commission said no, and then they couldn't, after negotiating, they couldn't agree, and they came to the Supreme Court for resolution there. And then another one where the county, due to some decisions that were made about some other sort of politically hot topics, attempted to tell the district court that they were being moved to an old gymnasium out of the current court building, and that would be where they have to hold court. And so those are the type of situations that have risen to litigation. It's never been those situations about a reasonable and necessary budgetary requests in the budgeting process where we go back and forth and decide what appropriate resources are. Again, we're getting at the situations where the lack of resources or the refusal to provide those inhibit the ability of the court to carry out its constitutional functions of receiving filings and timely disposing those cases.
Thank you. Our next question is from Assemblywoman Hanson.
Thank you, Madam Chair. Thank you for being here. I have a question on section 8.5, number 2. And if I'm looking at it right, this is new language, completely new, about a part-time judge may have a partner or associate who practices law in this state if the partner or associate does not engage in the practice of law before the part-time judge or in any court subject to the appellate jurisdiction of a court in which the part-time judge sits. I'm trying to understand, so a part-time judge, I'm trying to understand how, in the rurals in particular, where you might have, it's such a small world, how are you going to not have somebody come before you as a judge that you might, have as a partner on a case?
Thank you, John McCormick, for the record. I do want to apologize for neglecting to include this section in my overview. It was not intentional, and thank you. Assemblywoman, what this does, it actually mirrors the existing requirement in the Judicial Code of Conduct as far as part-time judges in practicing law. So, for example, in some of the smaller jurisdictions, you do have an attorney who is also a judge and they want to practice law. That is acceptable as long as, again, people who come before that attorney, he doesn't have judicial review, basically, over them. And so this situation would mean practically that if there was an attorney who had a partner, was in a firm in a rural location, was also the part-time judge, that he would have to make that decision. Do I want to practice in this court, my court, or do I want to be the judge here? This would allow that person to practice in other courts in the state, just not that court, or if where that individual sits, to maintain that independence. So the intent is actually to provide greater clarification here and marry up statute with court rule. And we have very few of these continuing part-time judge situations. I can think of one in Washoe County where the judge, if it has a practice, it's on the sort of the will trust setting that stuff up, so it's not really a practice where he would ever particularly appear in court. So that's sort of the genesis of this, and again, I do apologize for skipping over that one.
Just a quick follow-up to that.
Sure.
So, and I understand, we're at a loss sometimes to have staffing for this. So if we run into that situation, there's enough notice that it's not like you show up to court and you don't know this is going to happen, right? They're going to see who's been assigned to the case before it goes to the court, so they can make other provisions if they were to run into a conflict?
John McCormick, for the record, exactly. And generally, these continuing part-time judges are one-judge shops. So obviously, if Judge A's partner B was in a case in that court, we'd all know that judge would then have a duty to recuse, and then we could bring in a senior or a pro tem judge, or have a judge from a different jurisdiction. So generally, that would happen with plenty of notice. I can't think of a situation where a litigant would show up and run into this in terms of the judge not being able to sit.
Thank you. Our next question is from Assemblywoman LaRue Hatch.
Thank you, Chair, for the second question. I'm going to go to Section 5, which is about the electronic records. I appreciate the attempts at modernization. I also know a lot of the courts have their own e-filing systems and they have their own electronic records. I would like to know what impact this will have on those. Will they be forced to suddenly change to a different system? And if so, what supports will be offered on that?
Thank you, John McCormick, for the record. In terms of the rules that Supreme Court creates, those will be publicly vetted through our administrative docket process. So all jurisdictions will have an opportunity. Practically, as we've been working on those drafts, we've worked closely with staff at the 8th Judicial District Court and the 2nd Judicial District Court so far to draft the draft that will come before the court when it happens. So there's that. And then in terms of e-filing and supporting, if another court wants to stay with their existing system, when we do eventually roll out the full state e-filing, there'll be an interface there. We're not going to force, the 8th Judicial District Court to suddenly abandon their system and use ours. Those type of things will be worked out as we roll out the project. And so that's the intent on that. And this just says the court shall adopt those rules, and so through our general rulemaking process.
Thank you for that. Our next question is from Assemblywoman Cohen.
Thank you, Chair. Going to Section 2, I really appreciate having hearings remotely, especially when they're procedural. It saves money for the client, it saves time for me. But do we have any guardrails for judges who just don't want to leave their, Clark County's really big. A lot of our other counties, all of our counties are big, what am I saying? Our counties have a lot of space, and we can have judges that live, more than 100 miles away from where the courthouse is, or even if they just live in a different, neighborhood from the courthouse that don't want to come into the courthouse. Do we have any guardrails to keep there from being instances of our judges who just don't want to come in, or who want to maybe abuse, and I'm not accusing anyone right now, but that just kind of want to abuse the language. Even in Section 2, it talks about emergency. Well, what does emergency mean? I mean, I think we all know, we're all talking about COVID, or if the next type of emergency like that happens, but what if a judge looks at this and says, well, I have an emergency. I broke my foot, so I'm not coming into the courthouse, or I'm going to say that now we're going to start to have our hearings in Laughlin instead of in the courthouse in Las Vegas. So how do we prevent that from happening?
Thank you, John McCormick, for the record. We do have rules at the Supreme Court governing audiovisual appearance and remote hearings and all those kind of things. I'm not super familiar with those rules. Luckily, we have a team over there to deal with that. But those rules do exist, and I can get you a copy of them. And to avoid that kind of thing, and it goes through and assesses, this procedural motion, sure, we can have that remote, but, the trial, that should probably be in person. So it's trying to address that situation.
Great, thank you.
Thank you. And with that, thank you so much for responding to the questions, Mr. McCormick. I will go ahead and open it up for testimony. So starting here in Carson City, if there's anyone that would like to testify in support of Senate Bill 63. Not seeing anyone. Is there anyone in Carson City? I'm sorry, is there anyone in Las Vegas? We're all in Carson City. Not seeing anyone. Broadcasting, will you open the lines, please?
To testify in support of Senate Bill 63, please press star 9 now to take your place in the queue. There are no callers choosing to testify in support at this time.
Thank you. Is there anyone here in Carson City that would like to testify in opposition? Not seeing anyone, and there's no one in Las Vegas. Broadcasting, will you open the lines, please?
To testify in opposition to Senate Bill 63, please press star 9 now to take your place in the queue. There are no callers choosing to testify in opposition at this time.
Thank you. Then I will open it up for neutral testimony. Is there anyone here in Carson City that would like to testify in neutral? Not seeing anyone. Broadcasting, will you open up the lines?
To testify in neutral to Senate Bill 63, please press star 9 now to take your place in the queue. There are no callers choosing to testify in neutral at this time.
Thank you for that. Then I will, Mr. McCormick, would you like to come back up and, okay, so he's waving. He doesn't have any final remarks. So with that, I will go ahead and close the hearing on Senate Bill 63. Next on our agenda is public comment. So members of the community will have the opportunity to make a comment on anything outside of these three bills that we heard today, but that are still under the purview of this committee. Everyone will have up to 2 minutes. Is there anyone here in Carson City that would like to make public comment? Not seeing anyone. Broadcasting, will you open the lines, please?
To provide public comment, please press star 9 now to take your place in the queue.
Anne Marie Grant, ANNEMARIEGRANT. My brother Thomas Purdy was murdered by Reno Police and Washoe County Sheriff's Office during a mental health crisis, hogtied for over 40 minutes and asphyxiated by deputies. I would like to again urge you all to call on Attorney General Aaron Ford to exercise his powers under AB 58. I received a call. They have, there's a man inside the jail letting us know what's going on, and they have now moved him to H17, which is the mental health unit. He called reporting that once every 48 hours, they are letting the people in H17 out of their cells. He has been denied the right to a jail facility handbook. So once every 48 hours, he has an opportunity to look at that if he wants to waste his shower or phone call time doing that. But most concerning to me is the fact that he called about what occurred over the weekend, that he witnessed another inmate left completely naked without even a suicide mark. They did not bring him a blanket, and they left him stark naked in his cell. They put him in a restraint chair for 10 hours. I can provide the inmate's name that was being abused, but know that I fear for all of the lives of those at the Washoe County Sheriff's Office. I am not being dramatic. My brother and 2 other men died there, along with 13 plus people in 1 year due to the lack of humane care and torture they provoke at the Washoe County Sheriff's Office. In this particular mental health unit, the call buttons do not work, and deputies are not answering them when they bang for help, as the call buttons don't work, and this is the only means in which they can alert the deputies. This is a dangerous situation if they cannot get the deputies' attention. They are refusing to give this man, like I said, he's out once every 48 hours, and he did not have any behavioral issues. They told him he had 30 days in ag sed because he was providing folks with the NRS for other court cases. They then moved him to H17. He was simply moved to H17 out of retaliation. He has no idea when they will let him out of H17, nor do any of the others being tortured in H17 and the infirmary.
Okay, Ms. Grant, can you wrap up your comments, please?
Yes. Yes, ma'am, I can. She told her public defender refuses to contact him and told him, I'm working on your case, don't contact me, when he saw her face to face at court. Again, please stop ignoring what I'm telling you, especially you elected officials out of Washoe County. My brother lost his life at that hellhole. Thank you.
Thank you.
There are no other callers choosing to provide public comment at this time.
Okay, thank you for that. Well, thank you, members. Again, we have multiple bills scheduled each day for the remainder of this time. So with that, we're done with our business today. We are adjourned, and I'll see you all at 8 a.m. tomorrow morning.